Let's pass that Texas real estate exam with doing a sample test today. So how are you going to pass that real estate exam? You're going to practice questions, and the answers, and of course, vocabulary. So here we go. This is a real practice test. I got asked and I produced, okay? So here we go. So this is the book that we're using, Texas Real Estate License Exam by all these authors. Oops. Let me show you the book. Okay, so this is the exam that we're using out of this book, Texas Real Estate License Exam Prep from 2000 and late 2001. And so this is as if you're actually taking an exam. Hey, Cindy, good morning. So put your thinking cap on. The questions will probably be mixed up on here, all right? Because it is an actual, of course, it's not the exam you're going to take, but it is an actual practice exam for Texas only. So is anyone here from another state? Today we're focusing on Texas Real Estate Practice Exam. All right, so let's get with it. Good morning, Sophia, and good morning, Facebook user. Who is that? Okay, so whoever is on Facebook, go to StreamYard.com. Let's see here, .com/Facebook. Do it really quick. It only takes, a couple of seconds or maybe 5 seconds, okay? And give StreamYard permission to post your name from Facebook on here. Okay, because it's really important for us to see your name. And so I can't tell who it is that's on Facebook. So if you could do that, that would be awesome. Okay, that way we know who you are. And we want that. Oh, okay, it's Magenta, Jose Magenta, okay, from Georgia. Okay, so this is a practice Texas state exam. Okay, so it is going to have some national questions, but this will probably be something similar to your own state, Magenta. And however, it will have Texas portions exam questions versus something in Georgia. So I'm going to be buying some books from other states so that I can provide that to other states. Okay, so just be aware that today it'll be different. Darn it. Hold on here. Okay, here we go. Well, first I need to see my screen. Oh my gosh, what the heck did I do to my screen? I'm all over the place here. All right. Question number 1 for Texas License Examination Sample Test. A family temporarily installs produce coolers in a leased farm stand in order to prevent spoilage. The coolers would be considered which of the following? A, trade fixtures that are real property. B, trade fixtures that are personal property. C, temporary real property. Or D, emblements. And so far I've got Sophia saying B. Awesome. Anybody else? And Cindy says B. Okay, good. And yes, the answer is B. They are trade fixtures that are personal property. They can take them with them. Good morning, David. Grand Prairie, Texas here. Hey, I like that. Letting us know where you're from. Good morning, Fresme. I think that's your name. So the answer is 21B. Okay, so imagine that you're on the test exam day. Number 2. Property can be converted from real to personal property and from personal property to real property by means of which process, respectively. Okay, so you're converting it from real to personal in that order, and then personal to real. So A, assemblage and plottage. B, application and dissolution. C, severance and affixing. Or D, planting and harvesting. Okay, so you're converting from real to personal, and then from personal to real. So which would it be? Good morning, Lisbeth. Type your answer in the chatty chat. Yes, the answer is C, severance, right? You're removing real property from the person, from real to personal, converting from real property. So you're severing it from the property, and from personal property to real, you're affixing it, right? You're locking it down, tying it up, screwing it in, wiring it in, however it can be. Think about Maria. All right, number 3. The highest form of ownership interest one can acquire in real estate is the what? A legal life estate. B, conventional life estate. C, defeasible fee simple estate. Or D, absolute fee simple estate. Type your answer in the chat. Remember the bundle of rights. All right, doing good. Yes, it is D, absolute fee simple estate. It's the best type of ownership that you can have. What did I do? Hold on, I'm missing, this one. Hold on, I'm rearranging my, here. Dang it, dang it, dang it. Okay, it's because I've got 3 monitors, you guys, one on the left, one in the middle, one in the right. Okay, and I want to keep track of everyone that is posting the answers or having questions. Okay, very good. All right, number 4. Did I write the answer D? Okay, that's me. Wow, Lillie Handy. Yep, that's me. All right. Number 4, the distinguishing feature of a defeasible fee simple estate is that what? A, it can be passed on to heirs. B, it has no restriction on use. C, the estate may revert to a grantor of heirs if the prescribed use changes. Or D, it is of unlimited duration. So feature of a defeasible fee simple estate. So lots of definitions here. Or understanding topics. Okay, looking good. Yes, it is C. The estate may revert to a grantor or heirs if the prescribed use changes. So the property can be like donated or given a long-term estate or willed to someone with the condition that it has to be used according to how they recommend it. And if it's not, they'll take it back. The original owner, okay? So the key word is defeasible. Defeasible, fee simple. So fee simple, right? It has all the bundles of rights. However, it has a condition that it can revert if the prescribed use changes, okay? If they said, hey, you're going to use it as a park, and they don't use it as a park, the owner will take it back. That's a quickie example here. All right, number 5. Maria acquires a property from her uncle, Alfonso. When Maria dies, the estate will pass to Alfonso's other niece, Serena. The type of estate that Maria has in the property is a what? A, conventional life estate. B, legal life estate. C, fee simple, defeasible estate. Or D, tenancy by the entireties. Type your answer in the chatty chat. It is not C. That one doesn't have a condition. Okay, it says the estate will pass to Alfonso's other niece. Okay, so it won't go back to the original owner. This one is called a conventional life estate. Okay, the traditional type of life estate that the uncle Alfonso leaves to Maria, but when she dies, it'll pass on to another niece. Okay, Serena or Serena. Hi, Denise. Thank you for joining us. Okay, so did I type the answer? Yes, S5A. So go back and look at your vocabulary for conventional, legal, fee simple, defeasible, blah, blah, blah. Okay. Number 6. One difference between a cooperative estate and a condominium estate is that A, condominium owner owns a unit of airspace, whereas the co-op owner owns a proprietary lease. B, a condominium sale adversely affects other unit owners. C, the co-op owner owns stock and a freehold real estate interest, whereas the condominium owner simply owns a proprietary lease. Or D, the condominium owner owns the common elements and the airspace, whereas the co-op owner owns the apartment. So the difference between a cooperative estate and a condominium estate is that a condominium owner owns a unit of airspace, whereas the co-op owner is a proprietary lease, or condominium sale adversely affects the other unit owners. Co-op owns stock and freehold real estate interest, whereas condominium owns simply owns a proprietary lease. Or D, condominium owner owns the common elements and the airspace, whereas the co-op owner owns the apartment. And they call condominiums apartments, okay, for some reason. I guess at some time they were apartments and maybe converted. No, it is not D. Sorry to disappoint you. The answer here is A. It is a condominium owner who owns the unit of airspace. So they own the condominium and the airspace in it, whereas the cooperative, owns only a proprietary lease. So condominium, they own it. Co-op, it's a proprietary lease. Okay. gosh, I got a hair. All right, number 7. So anyone who just came on, we are doing a real Texas sample exam. Okay, so national and state questions will be mixed in. Okay, all in one. Of course, we will not finish the whole exam today. We will continue on, but this is a sample Texas exam, as you may see on your actual exam day. Not the exact questions, but maybe similar. All right, number 7. Who are the essential parties involved in an estate in trust? Essential parties involved in an estate in trust. A, owner, trustor, and lawyer. B, owner, trustor, and trustee. C, trustee, title company, and beneficiary. Or D, trustor, trustee, and beneficiary. Remember, there are 3 parties whenever there's a trust. What are the 3 parties? Type your answer in the chat. Doing great. Yes, it is D. You have a trustor, a trustee, and the beneficiary. Who is the beneficiary? The lender or the individual who created the trust. The trustor becomes the new owner. Okay, the trustee is whoever the beneficiary trusts to follow through with the deed of trust. Right? In the state of Texas, we have deed of trust versus a mortgage. Similar, it's just the difference is the approach for the steps to take for a foreclosure. Okay, number 8. So S7 with C. A condominium owner enjoys what? A, share in an association that owns one apartment. B, tenancy and common interest in airspace and common areas of the property. C, fee simple ownership of the airspace in a unit and an undivided share of the entire property's common areas. Or D, fee simple ownership of a pro rata share of the entire property. So we just did one similar, but not exact. So go ahead and type your answer in the chat. No, it is not B. Okay, it says a condominium owner. So it doesn't say plural owners. Okay, so it is not 2 or more. Okay, that's what makes it tenancy in common. This is not 2 or more. The answer here is C. Fee simple ownership of the airspace in a unit, so the whole condominium, and an undivided share of all the outside. Okay, the driveways, the lawn, the gated community. Okay, the pool, all that. Anything outside the condominium is shared space. It's common property, community property. So the answer is C. Go back and review what condominium is. So it's a fee simple. They own a full bundle of rights, ownership in the airspace in a unit. Okay, anything inside belongs to the owner, and undivided share. So everyone has 100% possession and use of the outside. Number 9, with various types of junior liens, not senior liens, but junior liens, the order of payment priority is generally established according to what? A, the date of recordation. B, what form of tax is in question. C, the order of disbursement. Or D, whether the lien was subordinated or not. So these are considered junior liens. What's the priority, the order of importance of those junior liens? Remember, there are start dates and end dates. No, actually, junior liens are all basically subordinated from the primary lien, and actually not. Some are mechanical liens, judgments. Okay, it's the importance here is when were they recorded? That's the priority. So the on junior liens, the priority for all liens is property taxes first, then the primary loan, the senior lien. And then after that, any money that's left over in the foreclosure goes to the junior liens in the order of being recorded. Okay. So the most important one always gets paid first, and that is property taxes. Then the senior lien, the main mortgage. The junior lien might be a subordinated lien, which could be a second mortgage. And then you have the mechanical liens, judgments, and child support, and blah, blah, blah. Okay. Of course, they're not going to call them blah, 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 but that's what I call them. All right. So that was number 9. Come on, number 10. Okay, that's not going to work. So let's try the other option. Dang it, it's going to be real small, y'all. Or kind of small. All right, number 10. What is a lien theory state in contrast to a title theory state? So a lien theory versus title theory state. A state in which liens are given priority over other encumbrances. B, a state in which a mortgagor retains title to the property when a mortgage lien is created. C, a state in which the holder of a mortgage lien receives title to the mortgage property until the debt is satisfied. Or D, a state in which liens must be recorded to be enforceable. Not quite C. The answer here, I'll give you another moment. See if anybody else is going to take a chance. Okay, the answer is actually A, a state in which liens, a mortgagor retains title to the property. I'm sorry. I'm reading the right statement, but set the wrong letter. B, okay, yes, you're right, B. Okay, a state in which a mortgagor retains title to the property when a mortgage lien is created. So the mortgagor, okay, is the borrower, right? And the mortgagee is the lender. So there's going to be a lien written in the title and on the deed. And they retain the title until the lien is paid. So a state in which mortgagor retains title. Mortgagor is the borrower, right? They get the title is conveyed, the deed is conveyed, the title is in their name to the property when a mortgage lien is created. Good morning, Sarah, Carol. So I typed the wrong answer, reading the right answer? So S10B. A doesn't apply. What did somebody else answer? Let's see. A doesn't apply because it said they have priority over other encumbrances. No, other encumbrances, could be liens or something overlapping onto their property. What did someone else answer? Nope, that was it. Okay, A or B. All right, number 11. A property owner has an easement appurtenant to her on her property, his or her property. One day the property is sold to another party who is opposed to the easement. Following the closing, this particular form of easement is what? A, terminates. B, transfers with the property. C, transfers with the owner to a new property. Or D, becomes a license on the property. So it says the property owner has an easement appurtenant. So what is appurtenant? Right? We know what an easement is, a right of way. Appurtenant, right, means it's attached to the property. It's part of the property. So when the property is sold, yes, very good. It goes with the property. It moves with the property. Very good. Awesome. Very good. Yes, transfers with the property. Number 12. What fundamental legal purpose is filled by title records? Okay, the legal purpose fulfilled by title records. Hi, Kamanani. Thank you for joining us. Oh, Cindy's putting the baby a nap. Good. So what fundamental legal purpose is fulfilled by title records? A, keeping the county apprised of tax payments. B, preventing identity theft. C, giving constructive notice of one's rights and interest in the property. Or D, assembling all relevant documents in a single place. So what is the importance, okay, of the title record, the legal purpose of title records? All right. Yes, it is C, giving constructive notice of one's rights and interest in the property. That is what the legal purpose of title records, when they're recorded, you give notice to the public of who the actual owner is. Okay, so let's see here. Kamanani says, oh, you mean you didn't pass? He's got 53 out of 56, 18 out of 21. Well, you're getting close, Kamanani. So the answer here, did I type the right answer? C, right? Giving constructive notice of one's rights and interest in the property. That was number 12. So whoever did not pass the exam, do not give up. Keep practicing, keep doing it until you pass. Yes, it hurts. However, don't be so hard on yourself. Because I know I failed. Okay. Sometimes when missing it by 1 point. Oh my gosh, that's when it really hurts. All right, number 13. What is chain of title? Chain, okay, what is a chain, right? And then of the title. A, the list of all properties who have ever owned real estate. B, the bundle of rights linked to the recorded title to a parcel. C, a chronology of successive owners of record of a parcel of real estate. Or D, involuntary conveyance of title by statutory rules of descent. Good morning, Rosaura. Thank you for joining us. We're doing a sample Texas exam. An actual sample exam, okay? As if you were taking it on the actual exam day. Well, actually in Texas, you'll get the national portion of the exam first or the state portion. They separate it. In other states, it's done together. What is the chain? Would it answer A? No, it is not A. It's not the list of all properties. It has to do, the chain of title has to do with one particular property, one specific property. It's the owners that change. So a chain is you have a chain of owners, right? Okay, so you have one owner here, another owner, and it keeps going. So it's a chronology of successive owners of record of a parcel of real estate. They want to know the history of ownership, okay? Make sure that it was properly sold, documents recorded, names corrected, all liens taken care of, and it was cleared before moving on to another owner. So chain of title, the title is to search what the successive owners are and any liens and encumbrances that are on it. It's not properties. It's one subject property. Okay. So the key word to the chain is chronology, right? A chain, you have a loop, one right after the other, right? When you have a chain. So think about a chain. You have one little link after another. So the different owners of that property are linked from year to year to year as the property is sold and bought. Okay, so we had answers all over the place, A, B, and C. It's not a list of properties. Nope. Out, out, out. And it's not a bundle of rights. A bundle of rights is a fee simple type of title that you have all the ownership, okay? So it is chain chronology, okay? In order, chronology, chain. Okay, those are the keywords there. Number 14, which of the following provides the strongest evidence of marketable title? A, general warranty deed. A, B, a title certificate. C, title insurance. Or D, an attorney's opinion. The strongest evidence of a marketable title. So you have the right to market the property. The strongest evidence, okay, keyword evidence, of marketable title. How do we know that you totally have ownership of that property and that you can convey it and that there aren't any liens? So the strongest evidence of marketable title is C, title insurance. So, all right, the title insurance does a search on the property of owners, any liens, anything that's due on it, any judgments, any encumbrances, any easements. So the title search and then a title insurance is provided to make sure that if any errors occur in the future, the borrower is protected. So it is title insurance, okay, is the evidence that you can market the property, that you can sell the property. Okay, so some of you answered 14A, which is general warranty deed. General warranty deed, the deed warranties, okay, it's the best type of warranty to have that has protection, right, for the borrower. Okay, a general warranty deed means it covers all the different owners instead of just a special warranty deed, but it guarantees, okay, that the owner has rights to convey the ownership of that property. It's an instrument to convey ownership, but the strongest evidence, okay, what gives evidence? The research, okay, to make sure that what's on the warranty deed is accurate. Title is, let's see. Kamanani says, title insurance, I thought it was general warranty. No. Two separate things, okay? Two separate things. Title insurance, okay, remember, it's the chronological order of ownership. Okay, and that's the evidence that someone can market that property. Warranty deed is the type of deed that is used to convey the property. Remember, there's general warranty, special warranty. So general warranty is a broad guaranteeing of that property. Okay, special warranty is it's only one owner. They say, I don't know the past. Okay, so the lenders, foreclosures, auctions, they'll give a special deed. They only know about this specific period of ownership, not all the history, all the chronology. Okay, so that'll be up to the owner on what type of deed they want to provide. So then the answer here was title insurance. Sophie from Houston to taking first-time test. Oh, awesome. We wish you all the best. Practice lots of exams. Practice, exams or quizzes from, national, some from state. This particular one covers, the whole state of Texas. Okay, good luck, Sophia. Okay, I failed by 2 points here in Houston too. Not a problem. Keep it going. Okay, the chain order. The chain order, okay, is the title insurance. Okay, and so the title insurance give evidence. The general warranty deed, general, is a broader type of warranty deed that covers all the different owners to the history of the property. If it's a special warranty deed, it's just for the particular owner now. Let's say an heir wanted to sell it, the administrator, the executor, they will provide a special warranty deed because it's for that specific ownership time. They don't know the past. Okay. So just some comments here. Best of luck on the second time. Kamanani is grateful. Thank you. I did pass national. Awesome. So right here, we're practicing both. Okay. So when you go back, you're only going to be taking the state, Stephanie. All right. Number 15. So in Texas, you either repeat the national or the state, or you can repeat both, right? But when you fail one, you only repeat the one that was failed. Okay. Number 15. Oh, wait a minute. Did I type the answer in? Yeah, 14C. No, I haven't typed. S14. I catch up with typing the answers in. It was 14C, right? Yeah, title insurance, S14C. Okay, very good. All right, number 15. A store owner enters into a lease that charges rent per square foot. Lease charges rent per square foot, okay? A common area fee and a portion of the store owner's gross income from the property. This kind of lease is, okay, so the store owner enters a lease that charges rent per square foot, a common area fee, and a portion of their gross income. So this is a kind of lease that is what? A, triple charge or triple net lease. B, proprietor's lease. C, percentage lease. Or D, retailer's gross lease. Oh, I typed the wrong answer. So what is number 15? Okay, so pay attention to commercial properties, okay, are charged per square foot. However, you've got to see the different things on here that are mentioned, per square foot, common area, and a portion of the store owner's gross income. The answer is actually C, a percentage lease, because they're getting the landlord is getting a percentage of that business owner's gross income. Okay, so they triple net lease and other leases, they're paying for utilities, for maintenance, property taxes, insurance. Okay, it doesn't say that here. So leases are typically, per square foot when it deals with commercial, and they could also have, and so that would be a general, a normal rental, okay, a normal lease. But here they're having store owners' gross income. So they're getting a percentage of a percentage, okay, of the gross income from the property. So that is C, a percentage lease. All right, so most of you said triple charge, and you said triple because of the fact that they said, oh, charge for rent per square foot, and secondly, common area fee, and thirdly, gross income, right? So you say, oh, well, that's 3 different charges. No, go back and look at the different types of net lease, triple net lease, okay, net. There's net lease, net lease, and net lease, which is a triple net lease, okay? Go back and review those. All right, number 16. Oops. An owner leases a property to a business in exchange for rent. The tenant is required to pay all operating expenses as well. This is an example of A, proprietary lease, B, percentage lease, C, gross lease, or D, net lease. So the tenant is required to pay all operating expenses. Okay, so what does it take to operate a property? Well, you've got utilities, you got maintenance, you got property taxes, you've got insurance, you got all kinds of stuff, right? So yes, this is a net lease. Very good. A net lease. So if you're having difficulty with these, you'll want to go and review information or the section, a summary about the different types of leases. I try to, Cindy, I try to adjust it as much as possible. Okay. So, I'll do my best. And so sometimes if I end up going too small, then, or too large and you don't see it all. Let's see here. Let's see if we see number 17. Okay, there you go. Number 17. Okay, so 16 was D. A lease automatically terminates under which of the following circumstances? A, the tenant fails to pay rent. B, the lease property is foreclosed. C, the tenant goes out of business. Or D, the landlord cancels the lease. So a lease automatically terminates under which of the following circumstances? So think about it here. When a tenant fails to pay, does it automatically terminate? When the lease property is foreclosed, maybe. When the tenant goes out of business, not necessarily. The landlord cancels the lease. Well, they got to abide by the lease. So this says automatically, the keyword automatically. What would automatically terminate a lease? If the property is foreclosed, right? Because who takes over? The bank. The bank doesn't honor leases or anything. The owner couldn't pay. They were receiving money. They misused the money. So it goes to the bank when it is foreclosed, and they do whatever they want to with it. So the key word was the lease automatically terminate. So what would cause it to automatically terminate? The only thing is when it is foreclosed. So Yesenia Kamanani got it right. Okay, very good. All right, number 18. A county of municipal authority usually grants a certificate of occupancy for new construction only after what? A, all contractors' work has been inspected. B, all work has been completed for at least 60 days. C, the construction conforms to building codes. Or D, the tax assessor has valued the improvement. So what is required when there's new construction and a certificate of occupancy is issued? Well, yes, it has to be inspected. It says all contractors' work has been inspected. Well, the work of the property is inspected. Okay. However, it's inspected and it has to meet certain building codes. Okay, so A doesn't give enough information, okay, compared to it's inspected in order to meet the importance of an occupancy, certificate of occupancy, is that all the codes required are passed. All the electrical, all the plumbing, the concrete, termite treatment, and once the house is built, there's another inspection to finalize it. So everything has to meet building codes. And there are a lot of different stages of how the city inspector, county inspector comes and inspects. It's mostly in the city. Counties don't have as much restrictions. They do go and inspect, like the foundation. But the city, they have different levels. Electrical. So the plumbing, okay, before the concrete is poured, then after the concrete is poured, and make sure they did a termite treatment for the concrete, then the electrical. So the structure is built on top of the concrete, right? So the first thing they do is dig everything to put the plumbing. So that has to be inspected. Once that's inspected, the concrete is poured, After the concrete is poured, now they can start the structure and they start wiring the electrical. The electrical comes and gets inspected. Okay. And then they start installing, the walls, the ceiling, the roof, everything that goes with it. And the structure, like the water heater, is it according to code? It has to be above ground. So there's a lot of different inspections, and they have to meet those building codes. It's a new structure, a new building. Okay. And it doesn't mean it has to be just a commercial building. It's, residential. Any improvements above the land. All right, number 19. Okie dokie. A property owner is precluded by deed restrictions. Okay, a property owner is precluded by deed restrictions from developing a 30-foot boat dock. The limitation prompts the owner to sell to another party. The new owner does what? A, is free to build the dock since the next door neighbor built a similar dock 2 weeks later. B, takes title subject to the same restriction. C, can build the dock with special permission from the zoning board. Or D, may build since the restriction is extinguished by the sale. So, what happens when there are restrictions? Okay, deed restrictions. There's city zoning restrictions, city building restrictions, and then there are deed restrictions. Those are even tighter restrictions from a particular subdivision. Okay, and it restricts them from building a 30-foot boat dock. So if they're in river frontage or, lake frontage, the limitation prompts the owner to sell. They're like, hey, man, I can't build that 30-foot dock, so I don't want this property. I'm going to sell it and go buy one that doesn't have that restriction. However, the new owner has now what? Can they do whatever they want, or do they have to follow the same restrictions? Awesome, y'all. Yes, takes title subject to the restrictions, the same restrictions. Restrictions don't change because there's a new owner. However, the owner could go to the variance, the adjustment board, and ask for a variance, right? And that's what number C was trying to imply. That they went to a zoning board or asked for a variance, okay? However, the main important thing here is that restriction takes title subject to the same restrictions. Doesn't matter who owns it, the restriction is there. This is a long one, so it's going to come out small. Okay, it's going to look kind of small, y'all. Let me see. Can I do anything different here? Let me see if I take it to the other type of screen, if it would be any better. Okay, maybe that's a little bit better. Okay, number 20. Emily sells Rycole a property containing a deed condition. The condition stipulates that the forested portion of the property must never be raised for development. 3 months later, Rycole proceeds to harvest the trees and turn the area into an executive golf course. What recourse, if any, does Emily have under the deed condition? So Emily sells Rycole a property containing a deed condition. Okay, so there's a condition. So what rights does she have? A, she has the right to repossess the property because the grantee has violated the condition. B, the condition has ceased to apply because she allowed the violation to continue for a certain period of time. C, she can claim the proceeds from the harvested trees. Or D, she can force Reichhold to sell the property to a new owner who agrees to comply with the condition. So what happens when there are conditions set? Somebody sells a property with a condition or conveys title, donates it, but they say you have to use it only for this purpose. Not sure I showed number 19. So what is the correct answer? We're on number 20, right? Yeah. Yes, very good. Awesome. Yes, she has the right to repossess the property because the grantee has violated the condition. So it reverts back, right, to the owner when they violate that condition. Awesome. Hi, Vicki. Thank you for joining us. We are doing a sample Texas exam. Number 21. I liked it when it was larger. So I have to change the okay, number 21. Oops, that's not going to work. What is the essential purpose of legal descriptions of real property? Legal description. How you identify a property. A, to create a consistent, unchanging standard for uniquely locating a property. B, to enable courts and attorneys to calculate property size accurately. C, to comply with common law for real property. Or D, to eliminate cumbersome metes and bounds descriptions. So what is the purpose of legal descriptions? All right, so Rosaura so far has A. No, the answer is actually A, okay? And reason being here, it's not for enabling courts and attorneys, okay? It's for identifying the unique location of a property. Okay, so you have a physical address, but sometimes the physical address are not accurate. So a legal description identifies the property. It can say certain subdivision, lot 20, block 9. Okay, so it's that particular spot, okay, on a planning map, okay, a plat map. It's not to accommodate courts and attorneys. It accommodates everyone that is able to find that piece of property. Okay, number 22. I'm still trying to get you a better, let's see. That, okay. I'm going to take myself out of that. Okay, number 22. So 21 was A. Which of the following characterizes metes and bounds descriptions? Okay, so the top one was legal descriptions. Okay, now this one is metes and bounds description. A, they use meridians and baselines. B, they identify an enclosed area beginning and ending at the same point. C, they use lot and block numbers. D, they incorporate elevation into the description. Which one is the best answer? All right. Yes, you guys are, you ladies and gentlemen are doing awesome. Yes, it is B. They identify an enclosed area beginning and ending at the same point. So they put markers, okay, at the beginning point and any area that they have to make a direction change. And they complete the loop and come back to the start point. Thank you for joining us, Shantae. And you got the answer right. So we are doing Texas, a sample Texas exam. Okay. Yes. All right, number 23. All right, number 23. Oh, thank you, Shantae. You're very welcome. All right, number 23. A buyer agrees to all terms of a seller's offer except the length of time for a contingency to procure financing. The buyer extends the financing period in the offer by 1 week, signs the form, and mails it back to the seller. At this point, the seller's offer is what? A, is void. B, becomes an executory contract. C, it becomes a counter offer. D, has been accepted since the modification was a contingency. So a buyer agrees to all terms of a seller's offer except the length of time for a contingency. The buyer extends the period in the offer by 1 week, signs the form, mails it back to the seller. At this point is considered what? So buyer agrees to all terms, okay, of a seller's offer except the length of time. The buyer extends the financing period in the offer by 1 week, signs the form, and mails it back to the seller. That's correct. It is void, okay? Because the seller has to receive it, acknowledge it, sign it, and if they don't, it becomes void, okay? Yes, it is a counter offer. However, it doesn't say that the seller's, so the seller's offer, yes, is void because the buyer countered, okay? So if it had said, so at what position is the offer? It's a counter offer, but the initial seller's counter offer, it's void, right? A new contract is taking its place and the buyer mailed it. So now the buyer has to wait to see if the seller is going to accept it and sign it and mail it back, right? Because they have to acknowledge. Yes, the initial contract is void and the counter offer is a new one. That's correct. They call it novation, right? Very, very good, Cindy. So y'all, you can read this here. So the original contract is void and the counter offer is a new one. That is correct. All right, number 24. Let's see if I take it to the next. Nope. Okay, number 24. Real estate contracts that are not personal service contracts are what? A, may be assigned. B, are not assignable. C, must be in writing. Or D, are exempt from the statute of frauds. Real estate contracts that are not personal service contracts are what? So one is actually right. We already know that they must be in writing, but what else? Well, especially if it's a contract that's a year or more, right? Because a lease doesn't have to be signed or in writing. So it doesn't say what kind of real estate contract, whether it's a lease, whether it's a 1 to 4 family residence resale. So contracts that are not personal service contracts, okay, can be assigned or may be assigned. Excuse me. So number 24, a real estate contract may be assigned. So it was written to tie it up, a buyer put it in their name, but then they said, hey, so I want to assign it to my LLC or to my corporation, or I want to assign it to somebody else, like when a wholesaler is bringing buyers and sellers together. Okay, then contracts may be assigned. So what did y'all answer? A. Okay, C, must be in writing. We have to be careful there. My first answer would say yes, it must be in writing. However, what if it's a lease for less than a year? Doesn't have to be in writing. Okay. So contracts may be assigned. Personal service contracts, it's like you have a personal repair coming to your property. You can't assign that and have somebody else, just take over that and repair it in the process of being, because that is a personal service contract. It depends on the company, okay, whether they can allow you to assign a personal service contract like termite treatment or, your AC yearly repairs or whatever. Sometimes they will not let you assign those. You have to create a new one. All right, number 25. Which of the following contracts must be in writing to be enforceable? A parole contract. B, a 6-month lease. C, a 2-year lease. Or D, an executory contract. So what I discussed for the prior question should help you answer this one. Which of the following contracts must, there's a key word here, must be in writing to be enforceable? Yes, awesome. A 2-year lease. Way to go. You're so smart. You're going to pass that exam, right? You're going to pass that real estate exam by practicing. Lots and lots of questions and your vocabulary. Oops, no. All right, number 26, right? Yes. All right. Agent Bob, who works for Broker Bill, obtains an owner listing to lease a building. Bill's other agent, Sue, locates a tenant for Bob's listing. Broker Bill in this instance is A, an implied agent, B, a dual agent, C, a single agent, or D, a subagent. Okay, so carefully. Agent Bob works for Bill. Actually, works with Bill, right? We don't work for somebody. We work under someone. Obtains an owner listing to lease a building. Bill's other agent, Sue, locates a tenant for Bob's listing. Broker bill in this instance is broker bill. Okay. Yes. So the broker, okay, is a dual agent. However, in Texas, we call it what? Intermediary, right? However, on this exam, right, this is a Texas exam, you're going to have national questions and Texas state question. So this is like a national question. So it is bill is a dual agent. Broker bill in this instance is a dual agent or an intermediary. Better make sure, yes. So dual agency occurs whenever a single broker represents both principal parties to a transaction. Here, since Bob and Sue work for Bill, Bill is the dual agent. In Texas, intermediary. Yes, very good, Rosada. In Texas, it's an intermediary. For national, okay? Yes, Carol was thinking about Texas. Just remember, this is a Texas sample exam that includes national and state questions. Whenever I do classes on the others, okay, I separate them because that's how the material is. But here, it's all combined. Okay? Okie dokie. All right, number 27. A transaction broker should disclose his or her agency relationship to a prospective buyer, to prospective buyers and sellers. Let's see if I put my picture in there. No. A, upon first substantive communication. B, upon completion of the listing agreement. C, immediately following completion of any offer. Or D, immediately prior to closing. A transaction broker should disclose his or her agency relationship to prospective buyers and sellers when? The best choice here, right, is A. IG Romero, thank you for joining us. We are doing a sample Texas state exam, which includes national and Texas questions, all mixed in. Yes, very good. Okay, number 28. Well, that won't work. All right, number 28. A transaction facilitator is a residential transaction. In a residential transaction, hold on. A transaction facilitator in a residential transaction represents whom? A, the seller. B, the buyer. C, both buyer and seller. D, neither seller nor buyer. A transaction facilitator. So what do facilitators do? Oh, I thought Kamanani was answering 28, and your response must be very delayed, Kamanani. No, it is not C. Keywords, facilitator. A transaction facilitator in a residential transaction represents whom? Neither seller or B. Okay, that could be like a transaction assistant. Okay, the title company, third party, they don't represent anything. They facilitate the closing. So the transaction coordinator, that's a facilitator. They do all the documentation in a residential transaction. They don't represent either party. So very careful. It's a facilitator. They don't represent anybody. They're a neutral third party. Yeah, that got most everybody. Not all, but most. Okay, number 29. Let's see. I like the big letters, but it doesn't include it all in one. Okay, let's try the other type of screen. Doop-de-doop-de-doop. No. Okay, let's see if I shorten the screen. Okay, there we go. Number 29. Okay, so Carol says, okay, so you all understand, right? Transaction facilitator is a neutral third party. You might have one of those, a transaction coordinator, once you get really busy in real estate or you don't want to do all the paperwork. So 29, a principal instructs an agent to inform minority buyers that the property for lease was just leased an hour ago and is no longer available. The agent refuses to comply. In this case, so the principal instructs an agent to inform minority buyers that the property was leased just an hour ago. Agent refuses. What happens? A, the agent should exercise caution until the listing expires, then decline to renew it. B, the principal has proposed an illegal act which should not be obeyed. C, the agent is liable for breaching the listing terms. Or D, the agent may sue the principal for discrimination and misrepresentation. So principal instructs. Yeah, we're trucking, right? Principal instructs an agent to inform minority buyers that the property for lease is not available. So minority buyers, right? Discrimination. So the answer here is yes, B, right? The principal has proposed an illegal act which should not be obeyed. Listing agent can terminate the contract, the listing agreement. If the seller wants to continue doing that, then I recommend highly that the listing agent terminate the contract, terminate the listing. Okay. We do not want to be involved in any situation that discriminates. Number 30. The amount of a real estate, did I show the answer for B? Yes. Okay, there we go. The amount of real estate broker's commission is established by what? The real estate broker's commission is established by what? A, agreement among competing brokers. B, negotiation with clients. C, the local board of realtors. Or D, state real estate license law. Hey, y'all are with it. Quick answers. Yes, it's negotiable, right? Negotiable with the clients. Hey, if you can get 10% commission, all the power to you. That will most likely happen maybe with lots, because lots a lot of time cost less than most homes. However, it is negotiable always. And if ever in a situation where someone is talking about, locking fees or, to get more listings, walk away. Do not be involved with anything like that. That's monopolizing. That's illegal. All right, number 31. Very good, y'all. A client revokes an exclusive right to sell listing 2 months prior to expiration. The reason stated, the client is too busy to meet with the agent. In this case, what happens? A, the client is criminally liable for negligence. B, the client may be liable for commission and marketing expenses. C, an agent can sue the client for specific performance even if no customer has been located. Or D, the agent must accept the revocation without the possibility of damage recovery. So can a client or an individual terminate a contract without reason? And if they do, what are the implications? What are the ramifications? Process of elimination when working to resolve issues is what we do, okay? So suing somebody is like the last thing, going to court. So the answer here is B. The client may be liable for a commission and marketing expenses. Remember, there's resolving things amongst us. There's mediation, arbitration, and litigation. And of course, specific performance according to the contract. So the owner is not performing to their contract. They're expiring 2 months early, right? And however, they can only revoke it with the agreement of the broker. So if the broker lets them out, they may not have to pay for commission or marketing expenses. Okay, but if the agent says, yeah, man, I did a lot of work and I want the commission and marketing. And so it said the reason stated the client is too busy to meet. Okay, well, there's a legal contract in place. So the answer B. Okay, number 32. A protection period clause in an exclusive listing provides, so a protection period clause in an exclusive listing provides that what? A, the owner is protected from all liabilities arising from the agent's action performed within the agent's scope of duties. B, the agent has a claim to commission if the owner sells or leases to a party within a certain time following the listing expiration. C, agents are entitled to extend a listing agreement term if a transaction is imminent. Or D, an owner is not liable for a commission if a prospective customer delays in completing an acceptable offer. So let's see, so far. Okay, so some of you are answering late questions. 28C, nope. That was some time ago. So the protection period allows for a realtor or broker to collect commission if the seller ends up selling the property to someone or leasing it to someone that the property was shown to. So sometimes we can put a 30, 60, 90-day protection, send them a list of viewers, who viewed the property. And if somebody ends up leasing it or they sell it to them, then we are due the commission because we did our specific performance. So B, the agent has a claim to a commission if the owner sells or leases to a party within a certain time following the listing expiration date. That is the protection period clause. Very good. All right, number 33. So everybody did well? Yes. 33. Real estate advertising must conform to regulatory standards and requirements. One requirement is A broker may only place blind ads in social media outlets. B, a broker must have all advertising approved by the local real estate board. C, the advertising must not be deceptive. Or D, sales agents may only advertise in their own name. I forgot to show 32. So what is the answer here? So one of the requirements, a major requirement, yes, that's correct. C, the advertisement must not be deceptive. Very good. Awesome, awesome, awesome. Number 34. Okay, number 34. The three principal brokerage firms in a market agree to pay sales agents 15% more than any other competitor currently in practice. This is an example of what? A, collusion. B, price fixing. C, allocation of markets. D, steering. No, it is not price fixing. Sorry. Oh, I don't know. Yesenia. Oh, wow, Yesenia, you must have a very delayed response. 34 is actually an example of collusion. And what is collusion? Collusion is the illegal practice of two or more businesses joining forces or making joint decisions which have the effect of putting another business at a competitive disadvantage. They're not fixing a price, okay? They're colluding, they're cooperating to, give bonuses of 15% more than competitive brokers. So this is amongst us brokers as their fees or their encouraging realtors to go sell. So it's a firm. So the three principal broker firms in a market agree to pay sales agents 15%. Okay. So commission fixing or price fixing, okay, that is when we're charging less percentage to a client, okay, than the other listing realtors or brokers. Here it is, they're colluding amongst themselves to reward their realtors 15% more than other competitor currently in practice. So it is called collusion, which I've never used it in my years of real estate. Never, use the word collusion, okay? So 34A. All right, number 35. Two leading agencies jointly agree to raise commission charge to residential sellers to 7.5% of the sales price. Which of the following is true? A, this is perfectly legitimate business practices. B, the brokers have legally fixed prices. C, the broker have allocated markets. D, the brokers have engaged in legal collusion. So two leading agencies jointly agree to raise commissions charged to residential sellers to 7.5%. Oh, so Vicky says that collusion is not in the book. Yeah, okay, I rarely have seen it. So here they're charging their sellers, right, a certain commission. So this here is illegal price fixing, fixed prices. The brokers have illegally fixed prices. They're not allowing the negotiation between seller and broker because commissions are negotiable, right? So that is price fixing and it is illegal. Different than collusion. Collusion was awarding to their realtors. Here it's fixing the price for the seller. it has to be negotiable. Okay. There are some minimums, okay, for the work that is being done that can be charged, and that can be a standard of that company. Okay. But that's not fixing. It's just a minimum. So if the seller says, well, I only want you to charge me 1%, well, shoot, we've got to make money here. We're in the business of helping you get what you want in exchange for a fee. And 1% just isn't enough. Okay. Although there are some companies that do flat fees. That's not price fixing. Okay. Commission is negotiable. So very good, Lisbeth and Cindy. Very good. All right. So we've been doing this an hour and a half. We can go for another 5 more questions. We usually do 2 hours. So why don't we do that? Do y'all want to go 5 more questions? We won't be completing this whole test, so we will continue on the next session. Thank you, George. Oh, George, you changed it from G. Romero to George, or you have 2 different. Keep going, please. All right, keep going. I asked, I receive, and I comply. All right. So number 36. Very good. Thank you for your replies. Okay, let's see. Nope. Okay, gonna have to go to the other screen because otherwise it's gonna come out really small. Really, really small. Let's see if this works. Ah, man. Just like this. Okay, there we go. 36. Yes, yes, yes. Everybody said yes. Check it out here. Yes, keep going. Yes, keep going. Yes, I love it. I love it. Yes. Wow, unanimous, unanimous. Awesome, awesome. Thank you so much. All right, number 36. A sale contract contains an open-ended financing contingency. Open-ended financing contingency. A condition, right? Open-ended. If the buyer cannot obtain financing within a reasonable time, the deal is off. 6 months later, the buyer still cannot secure financing. Which of the following is true? A, the seller may cancel the contract since it can be ruled invalid. B, the buyer can continue indefinitely to seek financing and the seller's property must remain off the market since reasonable is not defined. C, the escrow agent is entitled to the buyer's deposit. D, the seller can force a lender to commit to a loan under fair financing laws. Really? Oh my gosh. So a sales contract contains an open-ended financing contingency. Okay. Remember, there's a start date and an end date to everything, right? And there are terms that say time is of the essence, right? So it cannot be open-ended. So the seller may cancel the contract since it can be ruled invalid. Okay, because the buyer is going 6 months later. Okay, so it was open-ended financing contingency, but the buyer still cannot secure financing. So that's 6 months later. So the buyer, can't obtain financing. That's a long time. So the seller may cancel the contract. Most contracts have a start date and an end date. Well, seller didn't expect open-ended to go for a whole year. Okay. So they do have the right since it can be ruled invalid. Better put a deadline. Because, some individuals do things like procrastinate, mañana, don't deliver documents in time. All right, number 37. There we go. Take me out of the picture. 37. In the event of a buyer's default, a provision for liquidated damages in a sale contract enables the seller to do what? Okay, buyer defaults. Provision for liquidated damages. A, sue the buyer for specific performance. B, force the buyer to quit claim equitable title. C, sue the buyer for the brokerage marketing expenses. Or D, claim the deposit as compensated damages for the buyer's failure to perform. So just a comment here, when you all see the word sue, that's like going to court, okay? They didn't resolve it, mediation, arbitration, all failed. Then they go to court, okay? Sue is not the way to go. A lot of people are sue happy. Yes, very good. The answer is D. Stay away from suing, okay? So Lisbeth, I noticed you choose some of the answers that have the word sue in it. Stay away from that. Okay. I'm not saying that it may never be a choice, but for the most part, there are clauses within a contract on what to do. And there's usually mediation, arbitration, and of course, liquidated damages, okay, according to the contract. And that's usually the earnest money. So here, claim the deposit, the earnest money deposit, as compensated damages for the buyer's failure to perform. Ha ha ha. Yeah, really, right? Sue happy? Woohoo! Sue happy? No, we don't want to be Sue happy. I'll tell you what, some people are, man. They threaten, I'm going to take you to court for minor things, okay? I mean, it's like, it costs a lot of money, but of course the loser ends up paying. But still, sometimes, it's the ego getting in the way. Don't let the ego, look at the facts and come to a resolution. And we as realtors are there to help come to a solution and to, point out the facts, okay, of a contract. And if we don't translate the contract, we can then say, hey, go to an attorney and get advice, legal advice. Okay. However, we say, well, the contract, this is what it says. And, but you just don't translate it. You don't refer it. The contract, according to the title company, they have attorneys. They're going to say, hey, the contract says, if you don't perform, all right, seller gets the earnest money. So the title company, the escrow officer, they're a neutral third party, right? They're being paid by both sides. They cannot lean one way or the other. They read the instructions of the contract and they have their own attorneys, okay, in place. And if the buyer and the seller want to take their contract to attorney, then they will do so and get their advice. Still has to agree with whatever is in the title company's attorney's decision per the contract. Okay, so S37D. However, avoid our goal here is to come to resolutions. Seller wants to sell, buyer wants to buy. We are the middle in person. We're their facilitator. However, we're getting paid a commission from the listing broker, okay, a percentage of their list commission, right, if we're the buyer agent. And so, we read the contract and we work towards resolving, find out what is the issue, what are they upset about, why do they want this, why can't they do this, and explain this is what happens, okay? All right, number 38. Yes. Which of the following is true of an option to buy agreement? Okay, an option to buy agreement. What is true? A, the potential buyer, the option E, is obligated to buy the property once the option agreement is completed. B, the optioner must perform if the optionee takes the option. but the optionee is under no obligation to do so. C, the contract can be executed at no cost to the optionee. Or D, it is a bilateral agreement. So, so what is the option to buy agreement? So which of the following is true of an option to buy agreement? All right, so we have D, D, B. No, okay. When there's an option to buy, it becomes a unilateral agreement for a certain period of time, and the buyer has to make a decision whether to perform or not. And so B is the correct answer here. The optioner must perform. The optioner is the owner or the seller or the lessor, must perform if the optionee follows through with the option. But the optionee is under no obligation to do so. Okay, so the owner, the option period, okay, it could be in the contract, right? There's an option period for the borrower to do their due diligences, to do their inspections, and we pay an option fee. Well, if they decide they don't want the property and cancel, terminate prior to 5 p.m. on the designated day, that's time is of the essence, then the only thing they lose is the option fee. That stays with the owner. They get their earnest money back. They're under no obligation. They have a right to terminate during the option period. However, if they exercise the option and decide, okay, I really want this house, then the optioner, who is the seller, the owner, must perform. Okay, but the buyer is not under obligation. If they follow through with the option and they don't perform, then they'll lose their earnest money, depending on, there's other conditions where they could get their earnest money back. Okay, so the option to buy agreement, so that is the option period within a contract. There's also with a lease option to buy, so they will lease the property for a year, for 2 years, and they'll purchase the property at today's price, maybe 2 years later, if that's what the option stated. And so they'll be renting the property for the 2 years and maybe paying extra towards a down payment. When the option comes to a deadline, they have to make a decision prior to the termination date of the option. If they exercise the option to purchase it, then they get a loan to purchase at the original stated price. If they don't, they lose everything. Okay, any down payment, any rental money, and the initial option fee. Now, Vicki, just look at, it's an option to buy. They can either buy it or they cannot. So at that point, it becomes a unilateral contract. Only one person has to perform. The seller is on a waiting period, or the landlord. Once the option is coming to an end, the buyer has to decide, I'm going to exercise my option to buy or to lease, okay, to buy, okay, and they continue on. But they are not locked in or under any obligation to exercise the option. Can the seller change the price? No. So if the seller and the buyer agreed on a price today to sell it 2 years later for, $300,000, seller cannot change the price. Now, if the option period expires and the optionee did not exercise the option, yes, the seller can change the price because the option period changed. Okay. No, pardon me. No. So if the option period expired, the buyer has to perform if they didn't decline or terminate the contract. But during the option period, they can cancel, they can terminate, but they'll lose any investment that they made. Seller cannot change the price because there is a lease agreement, there's an option memorandum, and there's a purchase sale agreement. And that stays until the buyer terminates. Okay, so I see. Since you broke that down like that, I love how you explain things. Oh, thank you so much, Vicky. Yes, so just remember, in an option period, it is a unilateral. Who has to perform? The buyer, the option E. Okay, so in an option to buy agreement, that's normally what we call a lease option to buy. Okay, and so that can be 6 months, a month, a year, 2 years. And so the option period will say, okay, I want that option for 1 year, 2 years. So they get to use it, they enjoy it, and then like, oh man, you know what, this house has too many problems, I don't want it, I'm going to terminate before the option expires. And they lose everything, they know that in advance, and they move out. Okay, very good. So it is not a bilateral. Bilateral is after the option period. Now both parties have to perform. Okay. And the seller has to sell, the buyer has to buy. However, a buyer can still terminate, but they're going to lose even more money and earnest money in addition to all the other things. So S38 was B. Okay. So go back and review option to buy definitions with leases or with contracts. Just remember, when it's in an option, it's a unilateral contract. After the option period, it is a bilateral contract. Both have to perform. Okay, very good. Okay, so since you broke it down like that, okay, thank you. You're very welcome. And I already answered seller cannot change the price. Okay. When it was agreed upon at the beginning, it has to be specified in the contract. Okay. Whether the seller could or could not. Typically, it's the price that to purchase is settled today, not 2 years later. And I know that because I tried to buy some lease properties. However, in the state of Texas, you can exercise lease option to buy for, I think, 6 months. Oh my gosh, I put S28DB and it's S38. Sorry, let me correct that on Facebook so I don't confuse anybody. Oh, that's weird. I guess I deleted it. S38B. All right. Yeah, the internet's a little crazy. 39. If a manufacturer that is the major employer in a small city moves its operation to another city, it is reasonable to expect what? A fall in housing demand, but no other changes in the real estate market. B, a decline in demand for all types of real estate in the real estate market. C, an immediate fall in the demand for industrial real estate, but no other changes in real estate market. Or D, an immediate decline in the prices for industrial and office real estate, but no impact on the residential market. So if a manufacturer that is a major employer in a small city, okay, will that have a major impact or not at all? So what do you think? Thank you, George. Yes, I am. I fixed the answer, but I was trying to edit it within the Facebook. Okay, so is it going to have a major impact or not? So you got a little bitty town and a major employer that employs a lot of people in that little town, and they decide to move to another city. What impact does that have on a small town? Type your answer in the chat. Okay, I have A, C, Actually, the answer is B, okay? And reason being is that you have a major market that's leaving, a major company that employs a lot of people that buy houses, okay? So that'll create a decline in demand for all types of real estate. Why? Because the people don't have jobs. All right. And that major employer is no longer in that little city. So when there's a major employer in a town, okay, people will come and buy real estate there or other things, or it might be a little bedroom company, a little bedroom town, right? And they live somewhere else and they drive there. But it'll create a demand, a decline in demand for all types of real estate in the real estate market for that little town. So a manufacturer, it's a major employer in a small town, moves its operation to another city. It is reasonable to expect, okay, that there will be a decline in demand for all types of real estate in that real estate market of that town, right? Because, let's see what the answer says, because that supports the departing company will lay off or fire new employees, causing some to leave town in search of work. Some of these because may also have to cease operations. Hence, the demand for residential real estate as well as for commercial and industrial will decline, and new construction will probably also halt, okay, until some other factor increases demand again. So that's the economics of supply and demand. So the economy is impacted, majorly by major employees, major corporations, technology, anything that's moving in or out, okay? People have to go where the jobs are or travel to where the jobs are. Then they have to downsize, okay? If they have more expenses to travel and eat out instead of being in their own little town. So, let's see, some of you said, C, an immediate fall in the demand for industrial real estate, but no other changes. Well, no. Okay, major employer, keyword, major employer. That's not going to affect necessarily other industrial businesses or real estate. It can, okay, but the main thing, it's going to impact real estate, housing, okay, within that town. And then others answered D, an immediate decline in the prices for industrial and office real estate, but no impact in residential market. No, if you don't have an employer providing jobs for the local employees that live there, people are going to start moving away. Okay, no money coming into the town. It doesn't necessarily impact the decline in prices, right? Because the people aren't going to buy whether prices go down or not. Okay, they don't want to be there anymore. No more jobs, no more money coming in, no more money for the local businesses to support the community, the economy of that town. So the best answer here, a decline in demand for all types of real estate. Because let's say there's a major Walmart that comes in. Okay, then you're going to have these other little franchises, other little businesses. Well, Walmart shuts down, goes away, all those employees, no money going out to the little local businesses. So boom, it impacts everything. Okay. Economics. I took an economics class. Very interesting. So that's the supply and demand. Okay. Supply and demand. So you got to think common sense. I mean, if you're in that little town and your employer left, do you care if the prices go down? Oh, no, man, you don't want to buy, right? You'll cancel your contract and lose your earnest money because now you're not going to be able to afford to buy that house. Okay, number 40. If a commercial real estate market is undersupplied, did I show the answer? Gosh, yeah. If a commercial real estate market is undersupplied, okay, supply and demand, it is likely that what? A, rental prices in that market will fall. B, rental prices in that market will rise. Yeah, I want to fly. C, rental prices will remain stable until equilibrium is reached. Or D, construction will increase to the point of equilibrium. So a commercial real estate market is undersupplied. It is likely that what will happen to everything else? Supply and demand. There isn't enough. Okay, then what? Rental prices in that market will rise. Yes. Okay. So commercial real estate market is undersupplied. Rental prices will go under. Low supply of something, prices go up. Oversupply of something, prices go down. Okay, so what did everybody? Okay, everybody answered B. Awesome. Very good. I'll read your answer in a moment, Cindy. Come on, Facebook. Come on, Internet. All right, so let's see. So the answer was B. Rental prices in the market will rise, right? Because you don't have enough supplies. It's like when we don't have enough gasoline, man, prices start going up, right? Okay, Cindy says, don't mind my answers today. I'll have to go back and do this again. My little ones are not having it. Pound mom life. Yes, huh? Yeah, that has a major impact. That's why. Remember last week, or when was it? Today's Saturday, Wednesday, right? All the alarms, alerts. Oh my gosh, that was a pain. That was so distracting to me. And I must have fixed it, right? Because no bling, 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 bling. When you're studying to prepare for your exams, okay, remember to find a place that you can focus, quiet. If you like music in the background, put some incense, put some, what do you call it? A humidifier or a scent, okay, that you like. Wear your cologne that you like, okay, or something that makes you feel good. Do that when you're studying, but be in an area that you're going to be comfortable studying so that you can focus, okay, to study without interruption, because interruptions, it takes quite a few minutes to, 10 to 15 minutes to become back focused again. But it takes, boom, an instant to lose our focus and become distracted like I did last session. Okay. It was so terrible. I really apologize for that. I was so distracted by the alert. And you want to remove all that. Leave your phone somewhere else. Don't look at anything else except what you're studying and what you're preparing to do. Okay. Because when you get to the exam, that's what's going to happen, right? You're not going to have any other distractions except for your mind wandering off and getting all panicky and anxious or whatever. So, that reminds me. So when you go to the exam, skip the first questions, the first 5 questions, okay, and the math. They are typically the hardest and will get you to become anxious and nervous. Skip those until you finish all the easy ones. Come back and do those later. So I think in Texas Pearson Review, you're allowed to click them for review and come back to them later. Remember, a future question could help answer a past question, and then you can change it. Just study every day. The students that have been able to pass the exams have shared with me, as I did, study every day, okay? Even if it's 30 minutes, an hour. Don't let the material go too long, stagnant, without reviewing it. Study every day. Practice lots of questions till you get 100 score, okay? When I finally took the exam and passed it the first time, man, I tell you what, I practice and practice and practice lots and lots of questions. I repeated the same questions over and over until I got a perfect score. All right. And then your mind starts to recognize those keywords, those answers, and the results, and how to understand the question. The more you practice something, the more you do it better, right? I go back to a child. A child keeps wanting to stand up, right? Before, you're carrying the child, right? And then they start to crawl. Then they start grabbing things, trying to stand up, and boom, they fall, right? And they try again, boom, they fall. Oh my gosh, do they give up? Heck no. Why do we all walk? Well, we never gave up, right? So never, never, never give up. If you really want this, never, never, never give up. Keep on trucking, keep on trucking, keep on going. All right, y'all. So, yes, just like, yes, Cindy has kids, right? And she's got the mommy life. So, yes, focus, practice, study in a comfortable place for you, and do it every day until you pass that exam. Let us all know, okay, that you passed the exam, or give us a warning so that we can put in a prayer for those of you who, like to pray. I do. And wish you all the best in your process and your journey to pass that exam. You will pass if that is what you want. Okay? So keep on, keep on, keep on going. And remember, I am a realtor. I'm a practicing realtor. Okay. So some of this I tell you from my own experience. I've practiced in 3 different markets, real estate. Okay. And I love to represent sellers. I do represent buyers too, but I love listings, the marketing aspect of it. And know that I'm with eXp Realty, and I am also looking for realtors to join eXp. It may or may not be a match for you. So when it comes time that you are evaluating brokers, hey, evaluate several of them. Don't make a quick decision and go because a friend, another friend, or a friend tells you to go there. Evaluate different brokers and see which one is a good fit for you, because our company, we are a virtual company. Our office is in the cloud, which is awesome. So I work out of my home. All of us work out of our home. We had to do that during COVID. eXp became a #1 company during COVID, or got to #1, pretty close to it, during COVID, because we were all virtual. And that is today. We buy things virtually, online, okay? Amazon, Netflix, Wish, you name it, groceries, right? We order them online and they get delivered. So what do? Right? We learn how to deal in the new virtual world. Okay, so yes, just like that. Thank you for what you do. I really appreciate you. You're very welcome, George. Vicky is going on her 3rd time because I want it. Awesome. And you keep going. Now, practice studying lots of questions and your vocabulary, okay? And Lisbeth, you're very welcome. Vicky, thank you. You're welcome too. And Carol, will you be going over math questions soon? I will continue doing this Texas exam, okay, until I finish this Texas sample exam. And it'll probably have some math problems in it, Carol. And then after that, I could do a session on math. All right, y'all. Until next time. Catch y'all later. Have an awesome Saturday weekend. Love y'all. I wish you the best always. Thank you.